Are you serious, Judge? With all due respect, I see that you read the briefs thoroughly.
You are acting in a disrespectful and discourteous manner, and that's not appropriate.
Never interrupt your opponent when they're making a mistake.
You've waived rebuttal.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, everybody, I got a really good one for you yesterday. The entire world of lawyer news blew up last night. You couldn't find a lawyer news website, which I'm referring to those as lawyer news websites. It's a websites that more or less are only for lawyers. Like you have to be a paid member or you have to be a lawyer, like Reddit r/lawyers or Law 360 and a bunch of other sources. All blew up yesterday with the audio from a Second Circuit Court of Appeals hearing in which an attorney got himself kicked out of court, literally had to be escorted out of the courtroom. This is a matter that is being prosecuted by an attorney named Todd C. Bank, a Kew Gardens, New York attorney with this website. This is the entire Todd C. Bank Attorney at Law website, at least that I was able to find. If there's something else out there, I didn't see it. Todd C. Bank claims to be practicing law to the highest standards in order to meet clients' highest expectations. He calls himself the annoyance lawyer. I represent plaintiffs in class actions that deal with what I call annoyance law, which encompasses various types of cases, including pre-recorded telephone calls, commonly referred to as robocalls, and unpaid consumer rebates and misleading email spam. And that sounds great. Like, I'm on this guy's side already. Like, yeah, consumer law, like fight for the little guy and like enforce the rights that nobody else is enforcing, or rather they're being enforced selectively because limited resources, let's be fair. I'm on this guy's side so far, but then we get to this hearing that he had, and I'll play the audio in just a moment. I swear, I'm not just trying to string you along here. I want to give you a little background because you'll really appreciate it more if you know what's going on. The case that he's there for is this motion to dismiss. His case got dismissed, and he is challenging the dismissal of his case in the appeals court. This Robert Doyle versus Douglas Palmer case is the lower court's dismissal, which I will go over in its entirety, but I'll just want to read the introduction. This case arises out of a challenge to a local rule of the United States District Court for the Eastern District of New York. This is important, and it requires a sponsor affidavit. Applicants to the bar of the court, so that's lawyers who are applying to be admitted to the court. I literally just did this in the District of Columbia in Washington, D.C. Literally just did this on December 2nd. Applicants to the bar of the Eastern District of New York must submit an affidavit, which is a statement under oath, from a current member of the bar, so a current participating admitted member who has known the applicant for a minimum of 1 year. This also happens to be the exact same requirement I was required to meet for Washington, D.C., stating what the attorney, the sponsoring attorney, knows of the applicant's character and experience. Plaintiff Robert Doyle brings this action against the clerk of the Federal District Court for the Eastern District of New York. So he is suing the court clerk, like the court records clerk. He seeks both a declaration that the sponsor affidavit requirement is unconstitutional and a writ of mandamus to allow plaintiff to apply for admission. Now, a writ of mandamus is also something very important. This comes from the very beginnings, the very annals of American history. A writ of mandamus is an order or request for an order that tells a court or other official, public official, to do their job. So if a court is not acting, or if a policing body like a sheriff or the police, I don't mean an individual police officer, we have reasons for that, but you could technically, if there was some affirmative duty that they had that they were not doing, a common one might be if you apply for a firearms permit and you are not denied and it's not acted upon and you're not granted either, and just sits there and they don't do anything, which is effectively a denial, but you can you can try for a writ of mandamus, getting a court to order the sheriff to process your license or something like that. Lots of case law around this, and you don't do these things without first looking all that up. You don't just go file a writ of mandamus. It's not like that. You want to do your legal research first, of course, and none of this is legal advice. But that's what we're here for. He's trying to get a court order ordering the attorney, Robert Doyle, I'm assuming he's an attorney, to be admitted to the Eastern District of New York without the one-year sponsor affidavit requirement. Defendant moves to dismiss pursuant to the rules, and so then the case is dismissed for failure to state a claim because this isn't as unconstitutional as the plaintiff said that it was. Now, that's a dispute in the courts, and so, sure, you would then naturally appeal to the appropriate appeals court, here, the Second Circuit. Now, why did I tell you all of that and make you wait? Because I want you to feel the weight, W-E-I-G-H-T. I want you to feel the weight behind where he is. He's not walking into a magistrate court. He's not walking into a lower court. He's walking into the Court of Appeals after having lost his case. And then, one more salient fact, he lost another case just before this, unrelated, but it might have contributed to what you're about to hear. So without further ado, I present to you in its entirety. We'll listen to it first, and then we'll talk about it, maybe break it up again. It's only 3 minutes long, and we'll hear what Attorney Todd Seabank has to say at his oral arguments.
Morning. I represent Robert Doyle, the appellant. I think our briefs were rather thorough, and at least to my satisfaction, addressed all of the issues, having reviewed the opening brief and obviously the reply brief as well. So my question is whether the court has any questions, because otherwise I'd just be essentially reading from or reiterating the points in my brief, which I'm assuming that the court is familiar with the issues. So my question is, are there any questions? No question.
I have a question.
Okay.
I don't understand why the appeal is brought. I mean, your client controls whatever affidavit he submits to get admitted, and if it's not an affidavit that he likes, he doesn't need to submit it. So I don't understand why you're here.
So what Judge Chin is saying is, why was the appeal brought? Which certainly could be a little bit of an offensive question, like, the appeal was brought for the reasons stated in the brief. But it's a judge, and the judge hasn't asked the question in a disrespectful fashion. It's a perfectly fair question to wonder why a pretty obvious issue has been appealed. So maybe there's some real reason, and that's what he's asking for, not trying to make a point of, you're not supposed to be here, why are you here? But rather, please enlighten us further. Why are you here? Your arguments don't seem so strong.
It's not a question of whether he likes an affidavit.
His due process concern is that because he has to submit an affidavit, if the affidavit is negative, then that somehow hurts him. But he controls who he gets an affidavit from, and he controls whether to submit it. And if he doesn't,
the affidavit requirement means that a attorney applying for admission to a court, back up. I'm licensed in Pennsylvania. That doesn't mean I automatically get into the federal courts. It's basically guaranteed. It's basically automatic as long as I file the right paperwork. But I have to do the right process, the right procedure, the right paperwork for each individual district court in the country. There are 3 in Pennsylvania, the Western, Middle, and Eastern District. There are 4 in New York State. There are 3 in California. There's 1 for Washington, D.C., 1 for Colorado. Each and every one of these, I would have to apply. And I am. I'm admitted to Colorado. I'm admitted to the Northern and Western Districts of New York. But why am I not admitted to the Eastern District of New York like Todd Seabank? Why am I not admitted to the Southern District of New York? Well, those courts have higher requirements. Those courts require you to be a member of the state of New York or the state of Vermont. 2 very arbitrary choices. Why those 2 states are favored among the other 48, I don't know. And they require this 1-year sponsoring affidavit. So Leonard French can't be a lawyer in the Eastern District of New York or the Southern District of New York. I'm simply not allowed, banned from the Southern District of New York until I become a member of either the state of New York or the state of Vermont. And actually, I agree with Todd Bank here. Not what he's about to do, but the basics, that this 1-year requirement is probably unsound, not legally connected to the purposes of the admission requirements. And I think I might actually do exactly the same thing he did and file my own lawsuit against the clerk of the court and say it is unconstitutional that I am required to be a New York State attorney in order to defend copyright defendants in federal court. I don't need to know anything about New York State law to defend copyright clients in federal court. Copyright is in the exclusive purview of the federal government. New York State cannot make or enforce a copyright law. So Todd Bank is not entirely wrong here, and you'll actually see that the judge agrees with him. But we're going to get to that. That's in the motion to dismiss. Right now, he's about to get upset at the judge for asking why he's here.
Doesn't like an affidavit, he can go get another one, right?
His fear of a negative affidavit, Judge, with all due respect, has nothing to do with this case.
The judge, according to Todd Bank, the judge has misunderstood, and the judge is focusing on the affidavit requirement and how the judge thinks that the client, the plaintiff, is upset about the affidavit potentially being something disfavorable. But if the affidavit is disfavorable, well, who's in control of filing the affidavit? Ultimately, it's the attorney who's applying. So if they get an affidavit they don't like, they just don't have to file it. Go get a different affidavit from a different person. If they're unwilling to give an affidavit that's favorable to you, well, maybe that's indicative of their favor of you. So find somebody who favors you, or don't get in. If you don't get an affidavit you like, you aren't required to submit it.
That was the explanation on what the perceived injury is.
No, it wasn't that at all.
What's the injury?
Are you serious, Judge? With all due respect.
So, are you serious, Judge? With all due respect, I'll just let it play.
I don't know what to say.
You know what? I withdraw my question. You can sit down.
Okay, well, thank you.
Thank you.
Thank you very much, Judge.
We'll hear from...
I see that you read the briefs thoroughly.
Listen, you are acting inappropriately. You are acting inappropriately.
I'm sorry.
Well, you are acting in a disrespectful and discourteous manner, and that's not appropriate.
So now you can hear that Todd Bank has walked away from the microphone, and the judge has now scolded him for acting inappropriately. I've turned up the volume a little bit. I do apologize for any loudness, but you want to hear what's going on in the background too.
Good morning, Your Honors. Assistant United States Attorney Matthew.
So this is the
Montgomery
defendant.
from
This is the clerk's attorney.
On behalf of defendant appellee, the district court properly dismissed this action for failure to state a claim. And unless the court has any questions for us, we rest on our arguments set forth in our brief.
All right, thank you. We'll reserve decision.
So now the defendant, the court clerk's attorney, the court clerk, through their attorney, has simply rested their case. They've made their point. They don't need to take up the court's time on oral arguments. Also, I'll remind you of an old adage from, I think it was Sun Tzu's Art of War. Never interrupt your opponent when they're making a mistake. So if I'm the defense attorney and I'm watching plaintiff's attorney basically get his butt handed to him by the judge, I might just be like, no, Your Honor, I'm fine today. Have a nice day. Let's continue.
You've waived it.
So he said he has a rebuttal, and a different judge says, you've waived it.
Please,
You've waived rebuttal.
Please, you've waived rebuttal.
You've waived rebuttal. You've waived rebuttal.
He really needs to yell it at him.
You're excused.
Take this.
You are excused.
Take this gentleman out of the court.
Take this gentleman out of the court.
Right now.
Thank
right
you.
now. I love it. He says, out of the courtroom? Like, he doesn't quite believe that he's been thrown out of the courtroom for his disrespect to the court. Like, he just simply can't believe that the judge would throw him out for having been disrespectful to the court. Yowza.
Sir, leave.
He put up a little bit of a protest. I couldn't quite figure out what he said there at the end, but then the judge reminds him to leave, kind of like a last warning, like, leave, or... But didn't have to say it, like, leave, or... or else you're going to be spending the night in the holding cell for contempt of court. That, I think, is what was happening next. So he stopped himself before he got thrown into jail, just like Leibowitz stopped himself before getting thrown into jail. And all why? Why did he even show up if he's not going to take what the judge has to ask seriously? Even if the judge is being a jerk, that's the judge's problem. And you can file a complaint against a judge, just like you can file a complaint against a lawyer. So if the judge is being that, which is this, I don't believe this is anywhere close to that. I don't believe this judge acted inappropriately in any way. But even when a judge acts inappropriately, you don't respond with inappropriateness yourself or disrespect. You remember that you're always creating a public record, you're always representing your profession, and you always conduct yourself with the utmost dignity, especially when in court making an appearance. I mean, that's just... What are the consequences from this? I don't know if this guy is going to suffer anything more. I don't think he's going to get a reprimand or anything. Maybe upon hearing about it, like his state bar, I don't even know if it's legal for them to like reach out and be like, hey, you shouldn't do that. I'm pretty sure that with all the publicity, he's learned his lesson. Well, okay, maybe not. But I'm pretty sure that he's at least aware that there's a lesson to be learned. How about that? So he did respond to Law 360's request for comment here. Bank provided a statement on Wednesday to Law 360 in which he said Judge Chin's question concerned a minor issue that had already been addressed in a previous filing. Quote, Judge Chin's claim that he didn't understand why the appeal was brought ignored what the essence of the case was about, which was the appellant's objections on constitutional grounds on what he would need to do in order to obtain an affidavit in good faith compliance with the Eastern District's requirement to obtain one. So he thinks that he's allowed to be annoyed at the court in a disrespectful way. I don't think so. Even if the judge didn't understand, even if the judge was being willful and obtuse, that's not a reason to be disrespectful to the court. But the story does not end here. Where is Mr. Bank coming from? Is he really making good arguments and then defending them in the Second Circuit Court of Appeals? Let's find out for ourselves by actually looking at the Robert Doyle versus Douglas Palmer memorandum and order dismissing the case. And we read the introduction. First, plaintiff challenges the foundation of the federal court's authority to adopt rules governing the admission of attorneys. Second, he claims that the sponsor affidavit requirement contravenes the Fifth Amendment's due process and equal protection clauses. Third, he alleges that it violates his rights under the First Amendment. None of these claims have merit. A district court has discretion to adopt local rules that are necessary to carry out the conduct of its business. This authority includes the regulation of admissions to its own bar. The practice of law is not a matter of grace, but of right for one who is qualified by his learning and moral character. And this is where I start to think, hey, wait, maybe there are some teeth to this. If I have the right to practice law because I have the degree, the license, and the moral character, I shouldn't be banned, I'll use, because barred isn't a legal word, I shouldn't be banned from applying and being admitted to the Southern District of New York and Eastern District of New York just because I'm not a New York State attorney, which is a very strange requirement for copyright law. Again, copyright is in completely federal purview. The sponsor affidavit requirement is a valid exercise of the EDNY's judiciary's authorities to adopt local rules related to an applicant's fitness to practice law. The court reasonably depends upon a lawyer's veracity and good faith and is therefore entitled to investigate the character of those who seek to practice before it. Relevant is a review of the local rules for the United States courts. It demonstrated that an admission requirement similar to the sponsor affidavit requirement of the Eastern District has been widely adopted by federal courts. 6 of those courts require the sponsoring attorney to know that applicant for at least 1 year. That's what I had to do. I had to find somebody in Washington, D.C. who knew me for at least 1 year. It turned out kind of funny. I asked opposing counsel, and they granted my request. So I got admitted to a court system to fight an opposing counsel who helped me get into that court system. That's what I'm talking about when we're talking about no shenaniganery. The opposing counsel it's not fair game to try and prevent another attorney from being able to represent. It's fair game to attack the case on its merits. So the opposing attorney was confident in their case, and they were confident that I'm not going to be winning anything just by becoming admitted to the court, and instead they granted me my request for a sponsorship affidavit. Now I know I could probably have gone, well, we'll get there in a moment. I could probably have gone to court and asked for that sponsorship requirement of 1 year to be reduced to just a sponsorship requirement. The court reviewed the admission materials for each federal court. The application forms for several district courts were not readily available. Western District of Arkansas, Central California, Eastern California, Southern California. These are actually pretty darn easily accessible. District of Colorado was no problem for me. Like, that's a $200 fee for a lifetime membership. So not a hard one to find, but okay. There is no legal basis for the elimination of the sponsorship requirement, but it may make it more difficult to gain admission. For this reason, the requirement that the sponsoring attorney know the applicant for a year should probably be eliminated. Most courts do not require the sponsor to have known the applicant for any amount of time prior to commenting on their character and experience. Local Rule 1.3a sets out the requirements for admission to the bar of the Eastern District of New York. An application for bar admission shall be accompanied by an affidavit of an attorney of this court who has known the applicant for at least 1 year, stating when the affiant was admitted to practice in this court, how long and under what circumstances the attorney has known the applicant, and what the attorney knows of the applicant's character and experience at the bar. The form affidavit that sponsoring attorneys are asked to fill out is simple, to the point, and should present no difficulty to the applicant. And in fact, yes, I had no trouble. Once I had found someone who knew me for a year, I had no trouble filling out this form and no trouble getting myself admitted. The worst part was that it's a mandatory swearing-in ceremony, so I actually had to drive to D.C. in the middle of that December 2nd ice storm. I found that to be a little unnecessary, but it was a very nice ceremony conducted by Judge Chris Connor, and it was lovely. So I guess it was okay. Still, I don't like the idea that I have to be a member of the state of New York in order to practice in the federal court in New York. I think I am going to challenge that. I will consider that challenge after what this judge said. It seems like he's open to that challenge. Plaintiff is an attorney admitted to practice in the state of New York. He allegedly wishes to become a member of the bar in a federal district court for the Eastern District of New York, but he contends he cannot comply with the sponsor affidavit requirement without compromising his beliefs or his self-identity. What?
What the heck?
He contends he can't get a sponsor affidavit without compromising his beliefs or his self-identity. To enable a current member of the bar to provide a reasonably accurate assessment of his character, Doyle, plaintiff, alleges that he must engage in certain necessary activities. Okay. They include the disclosure to the sponsor of his beliefs regarding philosophical, religious, political, social, moral, and ethical issues, and of a sufficient number of experience of his that demonstrate consistency or inconsistency with any of his personal beliefs. What? I didn't have to do any of that to get a sponsor. Like, okay, I disagree with the Washington, D.C. and EDNY courts requirements of a 1-year sponsor, and a sponsor who knows you for 1 year. I disagree with it. But I certainly didn't have to disclose philosophical, religious, political, social, moral, or ethical matters. My sponsor just has to say how they know me, what they know of me relevant to the practice of law. And he said that I had been opposing counsel in a number of cases, and that he believes that I'm a person of good moral character and competent legal practice. That's all he had to say. That's really all he had to say. And I didn't even write it for him. Like, I don't have to, it's not like you write it for them and then they have to, there's nothing here that's coercive or disclosing private and personal information. This is so weird that this is the argument. And now does this make more sense why the judges were confused? He contends that it would be virtually impossible for him to engage in the necessary activities to a degree that would avoid the non-negligible risk that the sponsor would be untruthful in stating what he knows of his character. What? We assume that the sponsor is going to lie on a sponsorship affidavit form for an admission? Are you kidding me? If I'm going to throw away my career by lying on a form, it's going to be not for your sponsorship affidavit. And that's a joke. That's a tongue-in-cheek joke. No one is at risk of me flipping onto the dark side or anything like that. But I'm just making the point. It's going to take a lot more to make someone lie under oath, especially when talking about someone's moral character and legal competency. Why would anyone lie about it?
Maybe he feels like his moral character and legal competency can't be fully understood until all of those things are known about him.
Yeah, we definitely saw a great example of his moral character and legal competency in that hearing, didn't we?
Well, that was his representation, right? That was
his lawyer. Well, this is his lawyer arguing on behalf of the client. So we can take them together. This is the lawyer's words. This is Todd Banks' words on behalf of Robert Doyle. He believes that taking this risk is immoral and claims that this belief is fundamental to his self-identity. And even if Todd Bank doesn't believe these things, and he's just writing them on behalf of his client, which is a perfectly normal thing to do, the attorney at least has to know that this is a stretch of an argument. To grant a motion to dismiss for failure to state a claim, a court must accept plaintiff's factual allegations as true, drawing all reasonable inferences in plaintiff's favor. So if there's confusion among the courts, or among the judges on the court, then they favor plaintiff. If they don't understand something, they favor plaintiff. So if they're dismissing after favoring plaintiff, it's because the dismissal was the right thing to do. I'm not saying dismissals can't be wrong and there can't be appeals. Sure, he's right to appeal if he believes that the dismissal was incorrect. That's the civil procedure we use for not being a violent revolutionary country. Instead, we use the civil process of the courts. That's why they're there. So use them. So they reviewed 94 United States district courts, 12 circuit courts, and the Supreme Court. Oh, here's a phrase we haven't seen before. The review was conducted under a court's direction called ex mero motu, a survey of the federal court's local rules. Let's see what ex mero motu actually means. So ex mero motu is out of mere impulse or of one's own accord. They could have just, I guess that is a good phrase to use. So ex mero motu, of one's own accord or out of mere impulse. So the court decided to conduct a review of the district courts, circuit courts, and Supreme Court on its own. Courts may take judicial notice of facts that can be readily determined from sources whose accuracy cannot reasonably be questioned. The survey revealed the sponsor's affidavit requirement is, in general, consistent with the admission requirements of other federal courts. United States courts have largely adopted their own sponsor requirements. 47 courts, 8 circuit courts, and the Supreme Court require a sponsoring attorney to affirm that the applicant possesses good moral and professional character. 24 district courts and the Supreme Court require affirmation from 2 or more sponsors. Wow, 2 sponsors. Now there, I also think that's probably a too great of a requirement. This is too protectionist, and it's meant to keep local attorneys local, and we're not local anymore. I practice copyright law nationally through bar admissions and through local counsel. It's not helping anyone by making it tremendously more expensive for clients to defend themselves in court. Relatively rare is the requirement that the sponsor has known the applicant for 1 year. Only 5 other district courts impose a similar condition. This requirement appears unnecessary. A sponsoring lawyer should not need to know an applicant for a year to fairly assess his or her character and experience. It creates avoidable problems for first-time applicants, as well as for those attorneys new to the New York area who might not have access to the same networks as many of their peers. It is recommended that the judges of the Eastern District of New York revise the local rules by removing the condition that the sponsoring attorney must have known the applicant for a minimum of 1 year. If the change is made, it is probably desirable to coordinate the shift with the Federal District Court of the Southern District of New York, whose local rules mirror those of the Eastern District. On a rare occasion, the 1-year requirement may needlessly exclude a worthy attorney who lacks the requisite professional and social connections. In our unequal society, we should be encouraging those on the lower end of the social economic ladder with less acquaintanceships with lawyers to enter the legal profession as a means to move up in status and to support themselves and their families, as well as to help others. This kind of cinches it for me. I am going to do exactly this and challenge the state requirements, challenge the requirements that I, a copyright attorney, have to be a New York State member in order to practice copyright before the federal courts. He said so many things here that seem to be in favor of removing that requirement as well. Now, I realize it hasn't been argued here. It's not up for discussion in this case, so I could be wrong. I'm prepared to be wrong, but I'll pay $400, maybe $800, because I'll try it in both, and we'll see if we can't get those overturned. I'm in Luxembourg right now, so I either have to do it through another attorney or I have to wait till I get back later on. So then Doyle claims that Local Rule 1.3 sponsorship affidavit requirement is unlawful because it results in an unconstitutional delegation of legislative power to the courts. We're going to start skipping because this is another 20 pages long. Basically, they say that that argument is baseless because Congress has the ability to delegate. Fifth Amendment claims, I don't understand where there is even the slightest connection to Fifth Amendment due process and equal protection. Maybe privileges and immunities to be able to travel from one state to another and not have the requirements of joining the new court system be so onerous that you can't do it. That's a privileges and immunities issue. Not a Fifth Amendment. Fifth Amendment issue is notice, or should I say a due process issue is notice and an opportunity to respond in a meaningful court that will sincerely adjudicate your claims and give you at least at a minimum some kind of reasoned opinion and not just a blanket denial without any sort of meaningful hearing. Fifth Amendment due process also includes what we call substantive due process, which means you have certain rights, but those rights are not implicated in this attorney's admission. Equal protection is probably closer. Equal protection means everyone should be protected by the law equally. So if the law favors attorneys who are able to get a 1-year sponsor and disfavors attorneys who are not able to get a 1-year sponsor, and otherwise all things are equal, like there's no difference in the assessment of either attorney's moral character or legal competency, so that 1-year requirement probably does violate equal protection, but this challenge on these grounds fails according to the court. Although the court does agree that the 1-year requirement it does need to be revised downward, probably to 0. The challenge here is not the 1-year requirement. The challenge is the affidavit at all. So he's going to lose on the affidavit at all and basically wins on the 1-year sponsorship requirement. And like I said, that's encouraged me to challenge the out-of-state attorney requirement as well, that you can't be an out-of-state attorney. Then he goes on to First Amendment claims that the requirement violates his First Amendment. Generally, the government may license and regulate those who would provide services to their clients for compensation without running afoul of the First Amendment. A lawyer's procurement of remunerative employment is a subject only marginally affected with First Amendment concerns. It falls within the proper sphere of economic and professional regulation. It does not target any speech based on its content or on the viewpoint of the speaker. Any possible minuscule impact that it may have on expressive activities does not rise to the level of a constitutional violation. So the judge is going to continue for a while here So in conclusion, the court suggests that the Eastern District of New York, and like they said, the Southern District as well, amend Local Rule 1.3 by removing the requirement that the sponsor has known the applicant for at least 1 year. The condition appears unnecessary for an attorney of the court to provide a fair assessment of an applicant's character and experience. So that's how his case got dismissed. And that's what he was arguing, or not arguing, or arguing with the judge instead of arguing his case. That's what he was doing in the Second Circuit before Judge Denny Chin and the panel of Second Circuit judges. Now, that's still not the end, because the reason this gentleman may have been so upset or so easily riled, I'm not trying to defend his behavior, I'm just trying to explain it, and this one's really interesting. So he also lost a case in the Second Circuit Appeals Court earlier this week about canceling Al Johnson's Swedish restaurant's trademark. So this is the Todd C. Bank of Kew Gardens, New York. This time, he's representing himself pro se. Appellant Todd C. Bank appeals the opinion of the U.S. Patent and Trademark Office, having granted Al Johnson's Swedish Restaurant and Boutique Inc.'s motion to dismiss Mr. Banks' petition to cancel registration of the Swedish restaurant's trade dress, or trademark, that, quote, consists of goats on a grass roof. Yeah. Yep. That's right. Your favorite Todd Bank, I'm the copyright attorney. Todd Bank Annoyance Law attorney went to court to cancel goats on a grass roof.
Do you need to have an interest in a trademark in order to file a petition to cancel it?
What an amazingly on-point question. And now Firefox thinks that I'm in Germany. This is goats on a grass roof. This is Al Johnson's Swedish restaurant. I'm just going to briefly show you some of these pictures. Please go look at them yourself on Google Images. I'm not trying to commit copyright. No copyright infringement intended. We all know that exonerates me, right?
Don't say that.
So yes, Brandon, you nailed it right on the freaking head. What does Todd Bank have a restaurant which has goats on a grass roof? No. So the judges kind of go, what are you here for again? Standing is a question of law this court reviews brand new when a plaintiff must show a case or controversy between parties to establish standing before federal court. The case and controversy restrictions do not apply to matters before the TTAB, the Trademark Trial and Appeals Board. Instead, standing before an administrative agency is conferred by law, by statute. A petition to cancel a registration of a trademark may be filed by any person who believes that he or she is or will be damaged by the registration of the mark. The party seeking cancellation must prove two elements: one, that it has standing, and there are valid grounds for canceling. To successfully establish standing in a trademark opposition prosecution, the opposer must plead and prove facts showing that he or she has a real interest in the proceedings and has a reasonable basis for his or her belief of damage. Typically, standing is not a demanding requirement. Regarding the real interest requirement, an opposer must have a legitimate personal interest in the opposition. Regarding the second inquiry, the opposer's belief of damage must have a reasonable basis in fact. There is no requirement that damage be proved in order to establish standing. But Mr. Banks lacks standing because he failed to plead such a real interest for his belief in damage. The TTAB concluded that he lacked standing. Specifically, it explained that the only grounds for cancellation is the claim of functionality in his trademark opposition. So a functionality, trademarks are not allowed to be functional. Patents are for functional things. If you make something that functions, you have to patent it. If you make something that functions and you want to use it as your trademark, not going to happen unless you meet some very specific requirements that show that the thing is not functioning as a trademark. It's not a functional thing. So the example that I like to tell people, you've driven down the road, you've seen those orange diamond-shaped road signs. They sit on like a kind of thin stick of a stand, and they've got like two springs at the bottom. so that if something hits them or if the wind blows or whatever, it bends instead of blows over and flies across the road. I'm assuming it works better than not having it. They tried to trademark that, saying that only that company was allowed to sell signs that had springs on the bottom. No, that's a patent. Patents are limited to 20 years plus a possible renewal period. Trademarks are as long as it exists, as long as you keep selling it in the market, as long as it is in the stream of commerce, used in commerce. That's the standard for maintaining a trademark. So they would essentially get a patent forever. And that's not right. So we don't do it that way. That's why trademarks are not allowed to be functional. The TTAB determined that Mr. Bank did not sufficiently allege standing for a number of reasons. First, the TTAB stated that Mr. Bank failed to plead that he has a present or prospective right or interest in the Swedish restaurant's involved mark, or any other fact sufficient to allege his standing. Second, it explained that Mr. Bank's pleading of standing is vague and does not relate specifically to the involved service mark. Finally, the TTAB concluded that the petition did not allege that Mr. Bank had a reasonable belief of harm. Mr. Bank contends that the TTAB incorrectly interpreted the standing requirements for a petition to cancel a registration by conflating the standing and merits requirements. Mr. Bank failed to plead a real interest in the proceedings and a reasonable basis for his belief of damage. He sought to cancel the Goats on the Roof registration as functional, alleging that the trade dress is, quote, demeaning to goats, which in turn is offensive to Mr. Bank and denigrates the value he and others place on the respect, dignity, and worth of animals. Right. As an initial matter, the sole standing argument raised before the TTAB is that the Swedish restaurant's trade dress was disparaging to himself as it is demeaning to goats. What? Are we kidding? Yet as Mr. Bank conceded before the TTAB, the Supreme Court's decision in Matal v. Tam, 2017, foreclosed his argument as it held unconstitutional the prohibition on the registration of disparaging marks under the Lanham Act. In Tam, the court held as unconstitutional the law's requirement, concluding that its prohibition on disparaging marks was invalid under the First Amendment protection. This is the Redskins trademark, I think. If that's not the Redskins case, it was along those same lines, that a disparaging trademark can't be denied registration because the First Amendment protects freedom of speech, and so the government taking action against speech can't do that. To the extent that Mr. Bank relies on disparagement either as grounds for his petition or as discussed below to establish standing, the argument is without merit. In any event, Mr. Bank provided no grounds for standing. He failed to provide any reason other than to allege the Goats on the Roof registration is demeaning to goats and that the respect, dignity, and worth of animals were affected by the alleged demeaning. For the reasons discussed above, the disparagement clause of the Lanham Act is stricken as unconstitutional. Wow. So just to summarize, he doesn't have standing because he is not a competitor or engaged in the manufacture of same or similar goods, or otherwise has a current prospective right or interest in using the mark. That last line is the law, and then these are explanations. So, yeah, he hasn't been making a great show of it in court lately, has he? Well, I'm not here to get down on him for anything more than that, but that was remarkable. Don't act like that in front of a judge. If you're having a bad day, better off just keep your mouth shut. I mean, just if you're frustrated with the judge, talk about it afterward. Talk about it with your colleagues. Talk about it around the water cooler. I mean, you can probably even rant about it publicly like this a little bit. I'm assuming there's a line, and you could go too far here too, but I bet you can go a lot farther here than you can in that courtroom. So you have lots of expressive outlets, and the First Amendment protects lawyers too. So a lawyer is allowed to go and express themselves and rant about how they had a bad day in court. Sure, I don't see any problem with that. Don't do it in court. Don't express your disrespect and displeasure for the judge in front of the judge. And I'm glad Mr. Bank had the wherewithal to leave when he realized that he was being asked to leave. That was very good. That was very, very good. Hopefully that's the end of it, and hopefully that's all he needed to learn his lesson. So I'm not here to condescend to him or anything. I'm amused. I'm amused, and I do apologize that it comes off a little bit condescending, but it is not meant that way. It's more like just I know better, and so I feel a little bit schadenfreude there. So let me know what you think of that in the comments below. Brandon, what did you think?
I think he's Leibowitz round 2.
Yeah, he needs to steer himself back into a good path before he goes down a bad path. We know what happens when they go down these bad paths.
Yeah.
We don't need any more Leibowitzes.
Is Banks on our radar now?
Yeah, Banks is going to be on our radar. There's a reason. So Banks is on our radar because he has personally, I believe I saw, he has filed pro se or represented in 47 cases. And so we need to figure out which of those pro se ones are ridiculous or not. So there's gonna be a lot of us attorneys who go through his filing history now because he's on our radar. That's another consequence of pulling something like this. I would expect it to happen to me. I'm not above it either. So thank you for joining me. That is our show. If you enjoyed, please don't forget to like and subscribe, and even click that bell if you want to see our daily lawful masses legal news and stories and education stories. So thank you very much to the people who make this channel possible. We require direct financial support from our patrons and sponsors and Twitch subscribers, and someday we'll turn on the YouTube membership thing when we figure out how in the heck that works. Thank you very much to our December $50 plus supporters: Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Rumble in the Bunghole, and Cute Grills in your area. Those will never get old. And the $5 plus supporters are scrolling on the crawl in front of me. I'm Leonard French, your favorite copyright attorney, coming at you from Luxembourg, the city so nice they named it thrice. And I will see you in the videos that drop. I love you all. Have a good one. Bye.